All right, well, good afternoon. As most of you know, my name is Rick Noll. I'm too old to remember all of your names, but I know some of you, and thank you for coming. What we're talking about today is the things that you might face as a journalist, as a newspaper reporter, as an editor, as a person who does communications in the real world, if there is such a thing out there. Something that you can use today as part of this organization, the Paisano and the Paisano Educational Trust, but also something you can take with you in your day-to-day practice and day-to-day work life. Some of you hope to do some writing at some point in time and get paid for it. You're always faced with the potential of committing libel. And we're talking about the law of libel. And what I'd like to do is kind of give you the big picture overview and then narrow it down to what you're going to be faced with. Libel is an area of law that's under what's called torts. Torts are just things that are physical harms or personal injuries, also harms from insult and indignity and shock where there's no contact necessary. You know, if you're in a car accident and you get banged, you might get hurt, physical injury. But the area we're talking about today is more or less intangible in the sense that no one has slapped you, no one has hurt you, no one is putting a knife in you, but it's just as important. It was so important that historically we've had laws that prohibit people from insulting or defaming others. And defamation is a communication which injures one in his good name or reputation. It is usually calculated to bring someone into hatred, contempt, or ridicule of his fellow man. And you say, well, okay, is this something new since we've had newspapers? No, it goes way back. For example, this fellow that some of you may have bumped into along the way, I think his name was William Shakespeare. Have you heard of him before? Well, Leo Garcia has done some significant research to tell us what actually Shakespeare said in his play Othello. So tell us about one's good name and reputation.
Who steals my purse steals nothing, steals trash. 'Tis something, nothing. 'Twas mine, 'tis his, and has been slave to thousands. But he that filtheth from me my good name robs me of that which not enriches him, and makes me poor indeed.
Thank you, Leo. Now, as Leo has quoted Shakespeare, yes, the point there is Shakespeare was recognized, as has all mankind, he who filches my good name and reputation, that person is really stealing something of value. Just as an aside, as an attorney, my reputation is on the line every time I file a pleading, every time I appear in court, every time I make a representation to another attorney. My good name and reputation is on the line. If I don't back it up with the actions and with evidence to show that I'm telling the truth or that I'm arguing properly, my reputation is gone. If you lose your reputation, I'm sorry, you just don't get it back. So when you're out there in the real world and doing things, whatever you're doing, whether it's counting nickels and dimes, whether it's writing for somebody, just remember your reputation precedes ahead of you, and unless you value that, you won't have it for long at all. So that's what we're talking about in the area of libel. And libel is written or visual defamation, whereas slander is oral defamation. It's spoken and heard. And some people say, oh, well, that means anything on TV, the radio, is slander. No, it's actually considered libel because it's in a tangible form. But in communications between people, that's where slander may occur. If it is videotaped, if it's recorded, then it may turn into libel. But they're both defamation. Now, what I've tried to do is put together a formula or recipe so you can identify or at least understand what makes up a cause of action for libel. A cause of action are those elements or those pieces to a puzzle that if you put them all together and prove them, you have what's called a cause of action for libel. Libel is recognized under Texas law United States law. Most states have libel statutes. As a matter of fact, Leo was telling me that his mother is a judge in Coahuila, Mexico, and in her courts, they will handle libel cases. And Mexico has a very robust system to enforce the protection of one's good name and reputation. So what are the elements of cause of action for defamation, whether it be libel or slander? First of all, the first run off at the top of the list is the language itself must be defamatory, either on its face, saying something that is really defamatory, or, as we'll see in a moment, it can be interpreted as being defamatory. So what are these types of on-their-face defamatory language? Words imputing a crime. Okay, so if I say Rudy stole $100 from the food bank, steal, take, that's imputing, that's stating point blank a crime. Words imputing loathsome or communicable disease, like Joe has, what's a loathsome and communicable disease now? What do you think? Ebola. Ebola, for sure. Anything else? Smallpox. Could be smallpox. Anything else? Chlamydia. Sexually transmitted diseases, obviously AIDS, anything of that sort. At the time most of these laws were written, the communicable diseases people were really afraid of were certainly tuberculosis. You didn't want to be around somebody with TB because it was catching. You could catch it. So that loathsome and communicable disease typically referred to something that was either impossible or very difficult to cure. So that's another thing. So if you're in a class, somebody says, whoa, did you know that Katrina has fill in the blank? Whoa! Well, she's going to be shunned by her fellow students and perhaps by the Paisano staff, although you would never do that. So what about the third one? What words affecting one in his trade, business, or profession? If you went around saying that Diane Abdo sells A's for a mere $1,500, what does that say? That would affect her and her trade, profession, or business, implicating that she's selling grades, which I think generally is considered not only unethical, probably illegal. And then number 4, words imputing unchastity. Okay, the words imputing unchastity used to be qualified unchastity of a woman. However, in modern context, we say unchastity in general. If you say he has had a whole number of affairs with people, that would reflect negatively on some male person. So if you start down that path, we're talking about somebody's unchaste character, then you do have a potential for being of defamation, particularly if the language is on its face defamatory. But that's only the first element. And then the last one there, it says, or the language is defamatory when viewed by the reasonable reader in the light of the surrounding circumstance. That means you do not have to say that he, she stole something, he, she murdered somebody. It may be implied by the surrounding circumstances. As a matter of fact, I tried a week-long jury trial probably 30 years ago. My brother and I tried it together. My brother's a lawyer, and we were in practice together at the time. And my brother's client was accused of, I think, slandering one of his customers. And the client had a business. And the business sold hardware, yard tools, and things like that, including chainsaws. And the storyline was this. My brother's client had this hardware business, and this customer came in, had been there before, and he was looking at a chainsaw that was one that they had bought. It was a refurbished chainsaw. And then thereafter, the customer left, but thereafter, nobody could find the chainsaw. It was gone. Well, the client, our client, didn't accuse this customer of taking it. Nobody could figure out what happened to it. It was pretty, let's call it loose inventory type business. Well, about a year or so later, the same customer comes back with this chainsaw, leaves it off for sharpening the blade and servicing. Not unusual. The owner, our client, saw it and said, wow, where did this come from? Well, you know, John Smith brought it in. Oh, really? Oh, I wonder how he got it. Okay, so the owner knew that the chainsaw was missing from his inventory from a year ago. So when the customer came back to pick it up, the manager said, the owner said, Mr. Smith, I was curious, how did you come by this chainsaw? Now, is there anything defamatory in your view of that scenario? Well, the customer decided that the owner was accusing him of stealing the chainsaw. That was the implication, at least, that the customer took. Well, it took a week of jury trial, have a jury say, nah. So ultimately, in the view of the reasonable reader, and they decided, or the reasonable viewer, they said, no, that language was not defamatory. It was not accusatory. It was a question inquiring as to how did he get a hold of this chainsaw. So you have to also take that into consideration when you're writing stories, when you're doing any kind of interviews for whether it be the newspaper, whether it be in private work for a company hereafter. Take into consideration how is what I'm saying going to be viewed by others. And sometimes it's very off the cuff, meaning it's not really a significant statement, but it turns out to be one in the view of the viewer or the person who claims he's been harmed. Okay, but we've only talked about the first element. Remember, we've got at least 4 elements here. The second element, it's got to be published to a third person. What does that mean? Published means it's got to be broadcast in some way, shape, or form. Broadcast, every week, how many issues of this paper do you put out? How many copies? 25?
4,500.
4,500. Do you hope that somebody reads it? Okay, so you have to look at that as 4,500 individual publications. And then if somebody takes it somewhere else or copies it, it goes online. Social media people get online. How many readers do you have there? Each one is a publication and a new publication. So the whole point and purpose of the newspaper is to get it published. So you have to look at that second element when you're in the business you're in as one that is going to happen. At least that's the goal. The third element is the words must be of or concerning the complaining party. Somebody who's not mentioned in a story or who has no relationship with the story can't complain that John Smith or Mary Jones was libeled. They weren't the target of the story. However, this is dangerous in one sense because you may think you're protecting yourself by saying a broad category of people, like all the people in the SGA are, lazy crooks. All the people on the varsity, football, baseball, soccer team are, fill in the blank, pedophiles. All the people in the faculty administration are no more than lackeys for the governor. You can fill in whatever you want, but those broad categories don't really protect you. There's a historic case, and I mean back in the 40s or 50s, 1940s, 1950s, concerning the store in Dallas. Have you ever heard of Neiman Marcus? Well, this newspaper columnist wrote a column about how all the sales clerks at Neiman Marcus sell cosmetics by day and are prostitutes by night. Well, needless to say, the sales staff at Neiman Marcus, cosmetic sales staff, which were all women at that time, took offense at that. And they sued the newspaper and sued the columnists, and the newspaper and the columnists defended and said, well, we didn't identify anyone. But what these sales clerks did is said, there are only 12 of us who are cosmetic sales clerks. You have libeled every one of us. And the court said, that's right. So when you pick a target group, remember, they can band together and say, we've all been libeled. The football team, the basketball team, the faculty, administrator, whoever it is, they can all say that. So you're not protected by using a broad paintbrush to say all these folks. Basically, don't do it. The last one, you have to say the complaining party's reputation must be damaged amongst a substantial number of people, and probably a respectable segment of the community. So, what does that mean? The person who's complaining has to have some damage. And what damage are we talking about? Damage to reputation. If it's an individual, if they lose their job, I think you probably have some damage there. If your position or your respect in your community is lessened, there may be some damage, although it's hard to quantify how much did that cost. For example, whether you're active in a church group or social group, if something is said about you or something's written about you that would be offensive to your group, then maybe that's enough to show that there has been damage. Typically, when you have this kind of thing happen in a business context, if somebody loses their job, for example, can you think of a recent instance, say last spring, when someone lost her job as a professor at UTSA? Anyone remember that story? Think about the Dr. Anita Moss story and look at what these claims or the elements of cause of action are. I'm not saying she has a cause of action or not. I'm saying you can yourself apply these and see, wait a minute, did whatever happened affect her in her trade, business, and profession? Was she identified? Was it published? Has her reputation been injured? And did she receive any damages? Well, she's no longer employed. I think that would qualify. Right. Even if you meet, that is, even if you have all these pieces to the causes of action together and it forms a cause of action, that's only part of the issue. You don't necessarily win just because you can prove you have a valid case of libel, because the person who's accused of libeling them, the entity, the business, the newspaper accused of libel, has potential defenses, which are on the next page. And these are things you have to become familiar with, not only as a newspaper journalist, but in the workplace. You have to remember that truth is always an absolute and complete defense. So if what you said was true, then you have a complete defense to libel. Remember also that nothing is in a vacuum. Most attorneys who file lawsuits usually use what people call a shotgun approach. You've libeled me, and oh, by the way, you've invaded my privacy, and also you violated some other thing. So there may be multiple claims, multiple causes of action. So if they fail on one, they may still get you on another. That's the shotgun approach. No one single bullet, if that won't get you, they're going to do a shotgun to try to hit you somewhere. But truth is always a complete defense to libel, and an absolute defense. Accidental publication without negligence or intent to publish the defamatory material to a third person is a partial defense. You say accidental publication. You hardly have an accidental publication in the newspaper. However, it could happen. How many times have you written something, whether it be a story or a paper for a class, and you're going along, and of course it's only 2 in the morning when you're finishing, and you say, I'm too tired to review it, it looks good enough. And then if you read it 24 hours later or 2 days later, you say, what does that mean? I dropped some words, or my spell check changed this word to a different word that now looks horrible. That's why the copy editors have such a critical job. They're protecting your backside. So be nice to your copy editors. Any copy editors here tonight? There they are. These people you owe your life to. So be sure you treat them well. Way back in the 1970s, when I was an editor of the Rattler at St. Mary's University, I relied upon the managing editor to catch things like that, and she did. And that's, we skated through without getting clipped by anybody. But accidental publication is sort of a strange way to do things, meaning how often is something accidentally published? Not very often. You can think up scenarios in days gone by when newspapers were prepared on waxed coated dummies, and you'd paste it together, and the press would take a photo shot of the entire page and run that. It was possible that something got peeled off that shouldn't have been peeled off because it was just stuck on there with rubber cement. And so sometimes the quote was, "He is not a crook," and somehow the word "not" got dropped, and "he is a crook" came out. That sort of thing can happen. It's really difficult to meet this qualification, but it doesn't excuse the libel. It only may mitigate or reduce the damages. Now, in slander, it's a little bit different. Slander is between generally two people may have a conversation and say, "Oh, Maha, you really did a terrible job on this or that, and I think you're a worst magazine editor ever." Is that slander? Well, it's a criticism. It could be slander, but if it's a one-on-one conversation, it doesn't make any difference. But if it's done in public, of course it's published to a third person. However, the accidental publication is we're having that conversation unbeknownst to the speaker. Heather's over there at the door listening, saying, "Oh my gosh, he's really giving her a terrible evaluation." That's accidental, but wouldn't it be incumbent on the speaker to make sure I know who's listening or who's around? So I guess you could think of a situation where you write terrible things about people, defamation, all kinds, all libelous things, put them in a locked trunk, put them in your carry-ons, go on the airplane, that falls off, it spreads all over the terminal at the airport. Okay, you come up with weird things, but those are not going to happen often. It's still, you shouldn't be carrying it around. The third one there, consent to publish the defamatory matter, is a complete defense where the complaining party has caused the publication. Frequently, this happens online, social media, like, "Oh, I went out and did this," and then somebody writes about it. Or, worse yet, a real life story from the Paisano was where somebody was admitted that they were the person who did something, and the Paisano picks up on that and it's published, and then they say, "You shouldn't have published that. That's, it's libelous." Wait a minute, you put it out there. And it was to the general public. So the consent to publish is more in the line of people who are doing self-promotion, and you're republishing their self-published libel or defamation. The big category that the newspapers generally deal with, if you're not dealing with truth in the article, is a privilege to publish. This one is sort of the ultimate gray area for newspapers and journalists and people who do communications work. Privilege to publish defamatory material may be a partial or a complete defense, depending upon the circumstances. An absolute privilege exists on the following occasions. It kind of means the following settings. If it's a judicial proceeding, a legislative proceeding, or an executive proceeding. These generally are governmental type issues or judicial issues. Judicial proceeding, yes, you can go into a courtroom and libel people all day long. It's being taken down on the record. Why? Because the trier of fact, the judge, is trying to figure out who's telling the truth. So if the witness is saying, as in my court hearing on Monday in Hondo, was the witness saying, "Oh, he committed adultery." Okay, that's libelous, of course, but it's within a judicial situation, and therefore it's permitted. Can that then be published in the local newspaper? No, not without committing libel. So that setting has a privilege, just like your discussions in here about whether a writer is doing a good job, bad job, or otherwise, could technically be libelous, but it's in a privileged position where you are commenting upon something that you have a right and obligation to do. A legislative proceeding, like there are all sorts of terrible things that are said about legislators within their own, I guess, conferences and hearings. If you go on C-SPAN or something like that, it's amazing what you hear. I'm not recommending it, I'm just saying it's amazing how much slander, libel is being done. Same thing with executive proceedings. If you're trying to determine whether somebody's an appropriate person for a position, you have the right to say things very bluntly, even if they would be considered libelous or defamatory. The last one is a qualified or conditional privilege exists where when the publication is for a proper purpose and made in a reasonable manner, or where there's a public interest in having the defamatory material published. If, big if malice or ill will is involved, that is the publication for an improper purpose or for an improper motive, the privilege will be forfeited. Then if it's forfeited, you end up looking at what are called exemplary or punitive damages, which are big dollars. Now, how would this work? Let's say Joseph says, oh, we need to go after the SGA because that jerk vice president insulted me 13 times in the 1/2 hour, and we just need to show them something. So the article is published saying how bad they are, and it says bad things about the vice president, whoever that may be. Guess what? That article had a improper purpose. It had no purpose other than to punish. You can't do that. That's why I think your advisor tells you, no, you have to be objective. Frequently, people will, they will hang themselves, basically, based on what they do. You don't need to do anything other than state the facts. But you can't go after anyone. As a journalist, you can't do that. You can sort of do that in a commentary or editorial, but not in calling it a news article. Now, I know I've kind of raced through that. Does anyone have any questions at this point?
Yes. Words imputing unchastity.
Mm-hmm.
I didn't understand.
The words imputing unchastity has to do with saying somebody is not a chaste person. That is, they are having extramarital affairs if they're married, that they have sex indiscriminately. I will agree with you, Leo, that the emphasis on chastity is not what it once was. But I think if you, many people still regard a chaste character as an appropriate thing to have in a long-term commitment marital relationship going into that relationship. So it's still important to a lot of people. But I can't tell you that, if you believe what you read, apparently no one from age 12 on does anything but have sex 24 hours a day. But that, we all know is not the truth. However, it is still important for people to at least have this sense of well-being in their own body so that they're not being accused of having sex indiscriminately. And that's a hard one to define anymore because our mores and morals have not changed, but they are certainly not what they once were. If some woman was alleged in the 1800s to be promiscuous, she would likely not ever get married. Yes, Joseph?
What about meetings that are not public? Like if you were to cover a meeting that wasn't open to the public, but you were to write a story on that, what about this?
Well, theoretically, if the meeting is not open to the public, a reporter should not be there, theoretically. So you're probably kind of in double violation. You violated whatever their meeting order is that says you're not supposed to be there because it's not a public meeting, and reporting on it is, compounding that. So if it's a non-public meeting, it's hard to understand how a reporter could be there. But if you are like many of these secretly taped campaign rallies where things are said that sound a little bit strange outside the meeting, it's probably not going to be the subject of a libel case, but it certainly is a difficult one to rationalize how that could be made public. Yes, sir?
Are there different rules for public figures?
Absolutely. You look at that qualified privilege, or the privilege area. The qualified privilege allows newspapers wide discretion to go after politicians or anyone who has their hand on the public monies. So whether it's the mayor, whether it's the city council person, whether it's the governor, whether it's the state legislator, national officers, senators, whatever, you have significantly larger, permission to go after them, and probably little or nothing to be done, much like with celebrities. They are out there always promoting themselves, and whenever you put yourself in the public light, as a politician or celebrity does, you're saying, go ahead and criticize me, and people do. The famous story about a former presidential candidate, now this was probably well before your time, his name was Gary Hart, and he told people as he was running, he says, "I am as pure as the new driven snow. If you don't believe me, follow me." And the reporter said, "Okay." So they followed him, and guess what? 2 a.m. he was leaving his girlfriend's apartment to go back home to his wife. That was the end of his political career. That wouldn't be the same today, but that's what happened. Bryson?
Where does the line drop off between public figure and regular citizen?
The line between a public figure and a regular or ordinary citizen can be very distinct, such as a public figure, you have to either put yourself out there as a candidate or run for office or try to get publicity for whatever you're doing as a public figure. An ordinary citizen is the guy walking down the street, the guy working his ordinary job. He's not promoting himself, but he can change that, suddenly becoming the leader of some organization or group that's doing something, and then he or she would be scrutinized, or could be. But if you're minding your own business, then you're going to be looked at as an ordinary citizen.
Would a person who's a leader of a school organization, would that be a public figure, or is that?
A person who's the leader of a school organization, like any of the student organizations on campus, the spokesperson, the president, whatever they are a public figure to a limited extent. It's open season on them in their capacity as that student organization leader. But you don't go behind that saying, and he, she dates, pedophiles. That's going too far, unless, of course, they're the leader of the young Christian movement or something like that. Yes, sir.
So, like in reference to public figures, how important is the public figure's platform in reference to assessing damages for a libel case?
How important is the public figure's platform?
Yeah, I guess like the magnitude of the platform that they have. Are there any ramifications with like how damages are assessed versus like if Rudy got sued for libel versus, I don't know, I guess a celebrity like Tim Duncan or something?
Well, I think if I understand correctly, assume that there is a valid libel case, and remember it's hard to get to a public figure because the defamer has a lot more latitude to go after them. But if it's a public figure who has lots of money, the argument that the trial attorney is going to make to the jury is, you got to make this hurt. You've got to make this hurt. And this person, they only make, $12 million a game, for example, as a sports player. So we think it's only fair to take 1 month's earnings to make them feel it. Otherwise, it's nothing. If that's what you're saying, yes, you're going to try to argue that. Now, is that justifiable? Probably not. Because in defamation, you have to prove some actual damages. Actual damages are hard to prove. Over the years, celebrities have sued newspapers, and the National Enquirer has been sued. All these kind of strange papers that thrive on just exotic and torrid stories about the celebrities. And years ago, now retired actress, comedian Carol Burnett sued, I think it was the National Enquirer, and she won the verdict, and she said, "I just want $1." And they gave her $1. Why? Because she didn't need the money. She wanted to make a point. And so it's not unusual for someone who's been defamed to get what they call a nominal award. The money is not important to them. It's just to say they did libel me, and what they said was false, and they shouldn't have done it.
If we got a quote from a official from the university, we usually have to go through communication. If for some instance we acquire that quote, and that employee knowingly goes against their PR code, which is going through communication, is that still a valid? And the university comes after us for it, would that still be a valid defense for consent?
The question, of course, that's raised is, even though apparently there's a bureaucratic filter system that the Paisano has to use to get a quote from someone on university staff or faculty, whatever. And if this person makes a statement to the Paisano that's not, quote, approved by the Department of Communications, the PR department, can the university go after you? I don't really think they can. It's not libel. It's not, you know, unless it's defamatory, then you got other problems. But if it's a quote from someone in a position that has the ability to make a comment, it's not your problem they did it. It's going to be their problem that they didn't go through their, quote, proper channels. So no, they can't come after you other than say, we'll never let you talk to anyone ever again. And that's a story in itself. That's another story. So that brings up another issue. Was there any question back here before I continue? Okay. Sometimes the Paisano is given access to information or something is shared with the Paisano that I think the person sending it to you is trying to get more publicity for his or her cause. For example, a letter recently sent to the Paisano says, I believe my rights were violated as an employee and as a human based on standard operating policies and procedures. I have not violated any policies and followed protocols to appropriately sever ties as soon as I received my job offer. I am deeply troubled that I have had to experience this, especially when I have witnessed other employees submit their resignations and leave with dignity and able to transition staff. Why was my situation different? In other words, the Paisano was sent a letter that apparently was sent to several individuals, but including, you know, high-ranking officials at UTSA, presumably with the hope that you would jump on his or her cause, you would do a story and say how badly this former employee was treated, that you would go to his or her defense and be the standard bearer for them. That's not your job. And if you published anything like this, it could be libelous. Remember, if somebody says something or writes something that is libelous, defamatory in any way, and the Paisano publishes it, or you publish it, for example, in a corporate newsletter that you're now editing, you are equally guilty of republishing libel. And you cannot hide behind and say, well, I didn't say it, he said it, or she said it. That won't work. That's no defense. That's not truth. That is, the word's not true. And you don't follow any of those things. It's not consented to by the person who is liable. So you have to recognize that sometimes somebody is trying to use you. It is not unusual for administrators or teachers, instructors to come to you and try to get chummy with you to see it their way and therefore support how they see what's going on as being unfair to them or as being what should be going on. You just have to be alert, conscious enough to know, I think we're being used here. And that's where the experiences you have here are very good because, let's face it, a lot of things you deal with on a daily basis on this newspaper, your fellow students don't have to deal with those issues and don't deal with those issues. The one thing this newspaper has always been is mature. That is mature in your judgment, thoughtful in the way you proceed, and if you have any doubt about what should be done, you have an advisor, you can call an attorney. How many student organizations can lift up the phone and call an attorney and say, I need some help? That's what you have, folks. Some of you have done that, and I thank you for doing that. And it's not that the issues are life-threatening, but you know, you're in a position where you have experience. That experience may be helpful to you, at least guiding you down a path that will be the least obstructive to your future. What other questions do you have? Let's see. Now, you'll see on that third page that I gave you, I just kind of tried to walk you through the process a little bit, things you ought to be thinking about, kind of a two-step process determining if there's a libel problem. If you see something in an article, you find something, you ought to look at it carefully, and that you can read through that later. But if it just smells funny, and this has happened to many of you, if it smells funny, just doesn't seem right, trust your gut. Go further. See if you can get corroboration. talk to the advisor. Certainly talk to your editor first, or if you are the editor, think about it, consult with the other editors and say, where are we on this thing? Does this thing make any sense to you? And if not, go up the chain. That's why you have the organization that you do. Now, any other questions on libel? Needless to say, we do not have time to go through invasion of privacy and get through your 6 o'clock meeting, but the invasion of privacy is something that's probably you're going to see more and more of, because pictures are always available on the internet, in the newspaper, and whatever. For example, this is a story I pulled out of the local newspaper several years ago, like 2016. Remember this guy, Tim Duncan? Well, Tim Duncan's, I think that's who that is. Oh yeah, Tim Duncan's photo was photoshopped into this realtor's ad. And guess what? Tim Duncan never gave him permission to do it, so he sued him. And won, of course, because that's called appropriation. Whenever you take a famous person like Leo's picture and put it as an endorsement for your product or your cause, then you are appropriating their likeness for your own benefit, even if you didn't make money on it. So you can't put these endorsements or these kinds of things in your advertising copy or anything else.
Does the photographer still also have standing?
You mean the photographer who
The
took
original
the...
photographer, yes.
Possibly. What the question is, what about the legitimate photo taken of Tim Duncan the first time around? Does that photographer have any claim? Well, if it's his photograph that the person photoshopped to convert to their own use, yeah, he's faced off with 2 people. The big gorilla in the room is Tim Duncan, because he's got the money to do something about it. The photographer has a copyright violation unless he actually sold that photo to Tim Duncan, and Tim Duncan owns the rights. These are things you don't know about. Just remember, libel, slander, all this stuff can be done in cartoons, can be done in videos, can be done in photographs, can be done in any medium that is visible and tangible. Any other questions? We will have to deal with copyright another day.
Thank you, Rick.
All right, thanks, guys.
Thanks for watching. Click our logo to subscribe, or click one of the videos for more from the Paisano. Leave a comment letting us know your thoughts and what you'd like to see us cover next.